Well, I know you guys are not here to listen to me talk, so we'll go ahead and get started. Hi, everybody. My name is Jackson Nutbeers, and I'm one of Spur's Public Programming Associates. Thank you so much for joining us today. Many of you here today are Spur members, so thank you so much for your support. If you're not a member, I encourage you to join to support Spur's ongoing work in using education, policy analysis, and advocacy to make our city and region more prosperous, sustainable, and equitable places to live. Your financial support enables us to continue our work, including the hosting of programs like today's. You'll find more information about our membership online at spur.org/join. Our next digital discourse is scheduled for Thursday at 12:30 p.m. It's titled A Home Run for Homes. In 2016, the City of San Diego implemented the Affordable Homes Bonus Program, which allows developers to build additional housing if they also dedicate a portion of the new development to be affordable. The program, which builds on top of California's existing density bonus law, has enabled a substantial increase in the production of market rate and deed-restricted affordable homes in San Diego. The newly released report, Home Run for Homes, Celebrating Success of San Diego's Affordable Homes Bonus Program, dives into how the AHBP is able to succeed in the face of skyrocketing housing costs. Come hear from the program's architects and conversations with experts from the Turner Center for Housing Innovation about how the AHBP could be more widely implemented to tackle California's ongoing housing crisis. And with that, I will turn it over to Wesley Tam from Urban Environmentalist to introduce today's program. Wesley?
Yeah, thanks, Jackson. Hi, everyone. My name is Wesley Tam. I use he, him, his pronouns. I'm one of the leads with Urban Environmentalists, the organizers for this event. Urban Environmentalist works to transform cities and towns into more sustainable, human-centered, and just communities through land use policy reform. We'd also like to thank our co-sponsors, Seamless Bay Area, Silicon Valley at Home, the Greenbelt Alliance, and Climate Resolve. So today, we will discuss the goals of CEQA, its successes and failures, and what it might take to reform this embattled law while maintaining or even strengthening environmental protection. As a quick overview, CEQA, or the California Environmental Quality Act, was signed into law in 1970 by then Governor Ronald Reagan. The act required all California public agencies to identify and disclose the potentially significant environmental impacts of their proposed activities. So really quickly, the CEQA process begins with a public agency determining whether a project is exempt due to certain conditions and classifications. If the project is not exempt, then the agency prepares an initial study to examine these potential impacts. Then, in fact, if there are potential impacts, then the agency prepares a draft environmental impact report, or EIR. And then through consultation meetings with different agencies and stakeholders, a final environmental impact report is prepared, and then the agency determines whether to move forward or not with the project. So I'd like to introduce our speakers today. First off, we have Chris Elmendorf, who is a Martin Luther King Jr. Professor of Law at UC Davis and an affiliated scholar with the UC Davis Center for Regional Change and the UCLA Lewis Center for Regional Policy Studies. He teaches and writes about election law, property and land use law, statutory interpretation, and administrative law. Next, we have Sadie Wilson, who is the Resilience Manager at Greenbelt Alliance, where she directs the Bay Area Resilience Hotspots research and leads smart growth advocacy campaigns to Contra Costa County. She brings prior experience in urban planning, equitable climate adaptation, and innovative public finance solutions, developed through research efforts at multiple Bay Area institutions. Next, we have Lisa Gauthier, who's our moderator. Lisa was elected to the East Palo Alto City Council in 2012 and currently serves as vice mayor. She previously held the positions of vice mayor in 2014 and 2018, as well as the position of mayor in 2015 and 2019. Lisa is the VP of Partner Success for the Silicon Valley Leadership Group, where she manages the relationships between member companies and SVLG. She is the proud mother of 3 young adults, a longtime resident of East Palo Alto, and an active community volunteer. Unfortunately, Alex Contreras could not join us today due to a last-minute conflict. But however, we are also joined by California State Senator Scott Wiener. Wiener represents San Francisco and northern San Mateo County in the California State Senate. Elected in 2016, Senator Wiener focuses extensively on housing, transportation, civic rights, criminal justice reform, clean energy, and alleviating poverty. He chairs the Senate Housing Committee and is vice chair of the California Legislative Jewish Caucus. He's the immediate past chair of the California Legislative LGBTQ Caucus. So, we obviously want this event to be an interactive conversation and, want you to spend as much time as possible engaging with one another. So I encourage you to use the chat box to share your thoughts with each other and the speakers. I encourage you as well to submit any questions that you may have by using the Q&A panel. It should appear as a bottom at the bottom of the screen or the top of your screen if you're using the mobile app. Yeah, and with that, I'll turn it over to Senator Scott Wiener for opening remarks.
Great. Thank you, Wesley, and good evening, everyone. Happy Election Day. So thank you to Spur for organizing this panel discussion on CEQA. It's an incredibly important topic that is finally starting to get more attention because of the situation at UC Berkeley that sort of finally tipped this subject into the public consciousness, where people started asking themselves, wait, what is it? There's an environmental law that would put a cap on the number of people who can be educated at one of our premier public universities. And that didn't make sense to a lot of people. They wondered, why is that an environmental issue if there are more students studying at UC Berkeley? And so then people started to see, wow, this is a law that's been doing this for a long time, because as I said on the Senate floor when we passed the legislation to fix that issue and to correct the horrible mistake that our court system made, what happened at UC Berkeley was not a bug in the CEQA system, it was a feature. That's how CEQA, unfortunately, as it has been construed by the courts and implemented in recent decades, that's how it's designed to work, basically to gum everything up and to give basically anyone who has time and some money to hire a lawyer the ability to pretty much obstruct anything. And just stepping back, CEQA is an incredibly important law in a lot of ways. It was created in the early 1970s in response to a series of, or just an atmosphere in California where all sorts of projects that were environmentally destructive were moving forward without adequate public review or environmental evaluation. Certain dams and freeway extensions and the bulldozing of entire neighborhoods in San Francisco, for example, and so on and so forth. And so the thinking was, when you're going to be taking big decisions that could be very impactful in the environment, you should at least have to step back and do some analysis and be fully informed and allow the public to weigh in. A good idea. Over time, however, CEQA has grown to the point where, as I like to say, it's the law that swallowed California. It applies to everything. It applies to any situation in which government is making a quote unquote discretionary decision that this has to undergo CEQA. And that could be a discretionary decision to build a brand new highway through the middle of a neighborhood, or it could be to get a permit to put new windows in your home, and everything in between. And so we've seen over time CEQA be used for purposes that don't always have a lot to do with the environment, to slow down or stop projects. We've seen CEQA be used to slow down or kill infill housing, the most environmentally sustainable kind of housing, literally used to attack or slow down or stop like an apartment building right by a train station. We've seen CEQA used to undermine public transportation or bike and pedestrian safety improvements. We've seen CEQA used to slow down or stop park renovation projects. We've seen it used to stop clean energy projects. And of course, we've seen it used to stop student housing or to cap enrollment at universities. This was never what CEQA was supposed to be about. And frankly, it undermines the legitimacy of CEQA, which is tragic because we need CEQA for true environmental issues, toxics, other kinds of projects, oil refineries, projects that actually create environmental harm that would do benefit from analysis and public review. And when CEQA starts to actually at times undermine environmental action and climate action, that's a problem. And so there's been talk for a long time about the need to reform CEQA, not to get rid of it. Some people would like to get rid of it. I'm not one of those people. CEQA is a very, very important law. But the question is, can we both reform the process so that it is a better form of government, so we don't have secret people objecting who never reveal who they are, or we make it really easy for anyone to use CEQA to obstruct the project, even though they have little to no public support. It's very anti-democratic when one person is able to gum up a project that has broad public support, and trying to move away from unending CEQA litigation, but also making sure that CEQA is actually advancing climate action and not undermining climate action. We know what we need to do to try to save our climate and not have a climate catastrophe. And that includes things like infill housing and public transportation and clean energy and so on and so forth. And so what can we do to refine CEQA so that it advances those goals instead of undermines them? And so that's the conversation I think is so important. In the meantime, what we've done is we've been gradually taking certain classes of project that are indisputably environmentally sustainable, environmentally positive, and we just remove them from CEQA. We call it ministerial approval. So it's no longer discretionary. Certain types of infill housing. I have legislation this year to remove on-campus student and faculty housing out of CEQA. I also have a bill to extend a prior bill that we did to create a CEQA exemption for certain kinds of public transportation projects, rapid bus service, light rail, bike and pedestrian projects. And that's okay. There are certain projects that should not be subject to CEQA because they're overwhelmingly going to be very environmentally beneficial. But eventually we do need to actually get to the heart of it and fix CEQA itself so that people aren't scared of CEQA anymore. We don't want people that are trying to do good environmentally beneficial things to say, oh my God, CEQA may cause this project to take 10 years instead of 6 months. It might kill my project, make it more expensive. I want to get to a place where people look at CEQA as, okay, this is the right thing to do. But we're not there yet. And there are a lot of stakeholders and interests who don't want to give up the power to use CEQA to stop something they don't like. And there are businesses that do that. There are times when labor unions will use CEQA to get a PLA, project labor agreements. And in the end, I think we should have just clear standards about what people are required to do and not allowed to do, and not have people rely on CEQA. I'm a supporter of labor standards so that construction workers are paid fair wages. It's better just to have those standards in place so that unions don't feel the need to use CEQA to get that. We should have clear environmental standards about how we build buildings and GHG emissions and vehicle miles traveled standards instead of relying on CEQA to do that. So there's a lot of work to do. I think there's a growing appetite to do it and a broader coalition to support it. And I'm optimistic that at some point we'll get it done. So thank you very much.
Senator Wiener, thank you so much for your talk and for your leadership in this space. You have really championed, or at least put forth some legislation that I hope will be helpful in the CEQA area. We're going to move to some of the questions, but before we do, we want to thank Spur again, the urban environmentalist, for the work and for having us here today. The first question we're going to bring to Sadie, and then we'll hear from Chris as well. To what extent has CEQA been successful in environmental protection and mitigation? What are examples of this? Sadie.
Thanks, Lisa. And thanks, Senator Wiener, for those opening remarks. So first off, as an environmental organization, our mission is to protect and steward our natural lands, our natural assets in the Bay Area. And so we wouldn't be getting involved in talking about CEQA reform and CEQA strengthening, except that it is a huge part of the equation in how we achieve a climate resilient future. And that really hinges on allowing housing and infill development in our existing communities. But that is not to say that CEQA should be thrown out. That is so far from the direction we're going. CEQA has certainly had a lot of important environmental wins over the last 50 years, and especially as a tool for environmental justice. That part of CEQA, needs to be maintained and strengthened, even though it was not created for that purpose. But in the way that it allows communities to understand potential impacts and have a voice in the process, it really serves to have procedural justice and allow communities to get involved in protecting themselves and their environment. But that has seen two sides. So I think a good example is one that's often used, but right here in Richmond, communities for a better environment have been battling Chevron and the city of Richmond for many years over Chevron's plans to expand their refinery operations. And so the case there is really a great example of how the community was able to halt this expansion because Chevron didn't disclose the impacts that those operations would have on the surrounding community, the huge environmental justice impacts. And so the court ultimately ruled to deny that EIR wasn't going to move forward, and the city and Chevron would have to prepare a new EIR. So it was a win. It was a win in that moment. But because of how CEQA works, it did not make any conclusion about whether that project would move forward eventually. It just said that that was not included in the EIR. And so I think that really highlights this issue with CEQA itself, that it doesn't make those designations about what is good for the environment or going to protect the environment. It just says you have to disclose that and come up with some mitigation measures. And so it's this ongoing battle that requires the community to take their resources to bring lawsuits and to fight this fight, rather than have those protections built into the system.
Thank you, Sadie, and thank you for that example of the work that Richmond is doing around the Chevron. Chris, can you answer the same question and let me know if you need it repeated?
So the question is, are there examples of CEQA being used to stop environmentally harmful projects or to improve projects? And surely there are. There's the Chevron example. There are a number of warehouse projects that have been, as we move into this new world in which Amazon is building warehouses and other companies are building warehouses for just-in-time delivery. A lot of those projects there have been environmental justice concerns, and CEQA has been used to delay those projects and negotiate community benefit agreements. There have been housing development projects near Tahoe and in other sort of outlying rural areas that have been stalled or blocked with CEQA. So sure, CEQA is a tool, and it's a tool that can be used to delay projects for a long time when there's a will to delay them. And sometimes that tool is used for environmental reasons, and sometimes it's used for non-environmental reasons. I guess, one thing I'd like to just point out is that while CEQA seems absolutely foundational to environmental law in California, if you go one state to the north, Oregon, nobody thinks of Oregon as a place that is not green. I mean, Oregon is a very environmentally friendly state. It's a very liberal state like California, but Oregon never enacted a law like CEQA, or so-called mini NEPA, NEPA being the National Environmental Policy Act on which CEQA was patterned. Oregon instead has a statewide system of land use planning and draws urban growth boundaries and allows very little development beyond the urban growth boundaries. But no project in Oregon ever gets held up over environmental review and analysis because they don't have I guess it would be called an OEPA or an Oregon Environmental Policy Act, unlike Washington and California.
Thanks, Chris. Let's stay there and talk a little bit more about the next question, which has to do with how have different stakeholders from real estate developers to labor groups, and I think we've touched on this a little bit, use CEQA to block environmentally beneficial projects like infill housing and transit. And again, Chris, if you could start with this question.
So there's a lot of anecdotes about the use of CEQA to block projects, including if not block, to at least hold up projects and to require developers to pay off a group that is threatening to sue. And that could be a community group, or it could be a labor union, right? The payoff might take the form of a project labor agreement rather than like a cash transfer. There are examples, at least anecdotally examples, of competitors that are trying to prevent, like one shopping mall wants to stop another shopping mall from opening, so they use CEQA to prevent the new shopping mall from opening, or at least to make it expensive to develop the new shopping mall. But it's really hard to know how pervasive this kind of so-called greenmail is, right? The use of CEQA to shake down proponents of development projects. Because these agreements that are negotiated in the shadow of CEQA threats are usually subject to non-disclosure agreements. They're not recorded anywhere. They're nowhere in the public domain. So some people say CEQA is a huge problem in terms of this kind of exploitation of the statute to achieve non-environmental objectives. And other people say it's not a problem at all. And ultimately, I don't think it's possible to characterize the magnitude of the problem in any very quantitative or objective way, because we don't have any variation between places where CEQA does apply and places where CEQA doesn't apply. So if you want to say, well, like, what's the effect of CEQA on housing production, or what's the effect of CEQA on mass transit projects, you would need to have a counterfactual world that you could observe where CEQA doesn't apply. And we just don't have that counterfactual world. We don't have boundaries where there's CEQA on one side and non-CEQA on the other side. And so what we're left with is sort of this war of anecdotes, where on the one hand, CEQA critics say, my gosh, look at this horrible example of greenmail. And CEQA proponents or enthusiasts say, well, but look at how few or what small share of projects are actually litigated. And it's true that the share of projects that actually face CEQA litigation is pretty small as a share of all projects. But of course, when you look at litigation, you're just looking at the small part of the iceberg that's visible above the water, right? And you're not seeing all the projects that were never proposed because of the seeming impossibility of overcoming a CEQA hurdle, or all the projects that became vastly more costly than they otherwise would have been because the project proponent had to pay off a bunch of groups that were threatening CEQA litigation.
Thank you, Chris. Sadie, same question for you.
Thanks. Yeah, I mean, just to add to that, you know, just being in the Bay Area and doing the work we do, we kind of have these, of course, just anecdotes, but you know, those all do add up. You know, each project that is delayed, that loses, you know, a stream of funding because of a lawsuit that's ultimately either, you know, thrown out or doesn't really go anywhere. And I think a perfect example is a project that we Greenbelt Alliance endorsed last year that was 100% affordable, located in downtown Livermore by Eden Housing, on infill parcel, you know, zoned for housing, checked all the boxes, and still it had was hit with a CEQA lawsuit that, you know, ultimately was lost, but because of, you know, it was dependent on LIHTC financing, it kind of had to reapply, and it just was, you know, took years more than it would have. And those are the exact projects that we need to be building and supporting. And so, you know, to have, you know, such an easy way to derail that process is a huge problem. But, you know, I think it's also important not to say, you know, it's just NIMBYs that are you know, behind these lawsuits, because it really is an issue of the tool. CEQA is an imperfect tool, and it leaves it open to really anyone that has a problem with a project going forward, whether that be for environmental reasons, you know, earnest in environmental concerns, or anything else. And so I think that's a real issue here in how we've seen it misused.
Thank you, Sadie. And for me, being in East Palo Alto, when we think about the future development that happens, we have some development that is primed for our shoreline and our wetlands area. And it is important to have somebody who's going to overlook that land to make sure it's going to be protected for the future. So there are times when these laws do come into place and they're helpful. We're going to move on to the next question. We see small steps being taken toward reducing CEQA requirements for certain projects, such as SB 922 for bicycle and pedestrian transportation plans, and SB 886 to streamline student housing production. And the questionnaires, how do you envision this momentum going forward? Can it go further? And we'll start with Sadie.
Yeah, I mean, these are some of the recent, you know, kind of patchwork fixes to CEQA that we've seen, you know, many of over the years. And I think, you know, there's something, but I think what we really need to see is, you know, broader exemptions and streamlining for infill housing, especially, you know, when we get to the root of CEQA as an environmental protection statute. You know, we are right now operating with CEQA holding back the infill housing that we know that we need, and that is at odds with that. And so, you know, that comes down to, you know, strengthening the exemptions and streamlining, but also really understanding what that project alternative is. What happens when we don't build infill housing, you know, in Berkeley or in Palo Alto, or anywhere else around the Bay Area? That project, you know, right now CEQA compares, you know, that one housing project to a no project, when that really isn't the reality. The reality is that, you know, those people that would be housed next to transit, next to high quality amenities in our communities are now going to have to travel, you know, live somewhere else and travel in, you know, and that results in more VMT, more sprawl, And really, more development into our wildland urban interface areas that is, has created this huge wildfire problem we're facing as well. So, that project alternative really needs to be thought about in a holistic way that considers, our regional environmental goals and our regional climate goals, as well as, the local context. But right now that's really missing from the CEQA, analysis process, and something that's really working against making this work for our climate goals. And, I think another piece that can be strengthened, CEQA wasn't created for environmental justice, right? It was created, in the 70s, really thinking about pollution and impacts and sprawl, but it has become a very powerful tool for environmental justice communities to use. And I think that needs to be, really thought about, in a nuanced manner. And, I don't think any CEQA reform should take away, the ability of CEQA to be a tool. But I think there are ways to strengthen CEQA as a way to embed environmental justice into CEQA analysis, rather than use it in this kind of, lawsuit way that, everyone else is using CEQA. So I think those are some places and to start. And I think it really, to have a bigger impact, I think it will take, having those environmental justice partners at the table as well when thinking about reforms. So not to say there's a lot of power in CEQA and we need to maintain that, but we also need to make it make sense for the environmental conditions we're actually facing today.
Thank you, Sadie. Chris, same question for you. Please let me know if I need to repeat it.
Yeah, that's great. So the question is, what are the paths or potential paths for CEQA reform? And I really agree with a number of the points Sadie made. There's some things about CEQA that just are illogical, right? They're just fundamentally illogical. Like, as Sadie pointed out, the assumption of CEQA that if a local government says no to a project, that will maintain current environmental conditions. When the reality is that if a local government or a state agency says no to a project, what that often means is more pressure for other projects in other places that may be much worse for the environment. In terms of reforms, I think one of the reasons why CEQA has turned into the beast that it is that there has long been a remedy in cases where a local government or a state agency improperly shortcuts environmental review, but there's no remedy under CEQA in cases in which a local government or state agency requires more environmental review than CEQA in fact requires. In other words, violates the law by going the other way. And there are timelines under CEQA in which CEQA reviews are supposed to be completed, but the courts have treated those timelines as unenforceable if a developer cooperates with a city past the timeline. And even if in theory, the timeline is enforceable, if the developer doesn't cooperate, the only thing a court can do is to order a city to make a decision. So in practice, there's absolutely no incentive for anybody to sue in cases where a local agency violates the law by requiring too much environmental review. So AB 2656, which is a bill sponsored by Senator Ting and that Spur has also worked on, would provide a partial solution, I think, to that problem in the specific case of housing projects that are protected by the State Housing Accountability Act. Beyond that problem of CEQA abuse, that is under the auspices of CEQA requiring studies and analysis and mitigation that CEQA doesn't actually require. Beyond that, I would say I would prioritize OPRs, or I would suggest that OPR, the Office of Planning and Research, can play a more policy-minded and forward-thinking role than it has to date in updating the infill exemptions in the CEQA guidelines. So there's a so-called categorical exemption for infill projects that's been in the guidelines for a couple of decades. It was written by OPR. It hasn't been, or OPR and the Natural Resources Agency. It hasn't been updated for a long time. I think it could be updated in ways that would make it more effective for streamlining projects that are good for the environment.
Thank you, Chris and Sadie. You know, due to time, we want to be mindful that we have audience participation, and there are a few questions that are in the question Q&A box. The first one was for Senator Wiener. I'm not quite sure that he was able to stick around for a question, so we'll come back to that and see if he's around and if he can address the question that's posed to him. But we'll start with, let's see, is it acceptable / legal for the same company that created the CEQA report for a city's general plan to do the CEQA report or do the CEQA reports for the project? Who would like to start with that? Chris.
I have no knowledge one way or the other on this. I don't see why it would be unacceptable, but I don't really have anything to add.
I'm right there with you, Chris. Yeah, I don't see why that would be a problem, but I do not know.
Neither do I, so I can't chime in on that one either. The next question from the audience, is there an available analysis on the number of housing projects as well as units lost off of projects that have been stopped by CEQA? I have read and seen many projects downsized or killed, but haven't been able to find any quantification of this.
So I will take that question and I will repeat or elaborate on a point I made earlier, which is that this question cannot be answered. And the reason it cannot be answered is that we have no idea what is the universe of projects that would have been proposed in the absence of CEQA. So you can quantify what share of approved projects were subject to CEQA litigation. And Moira O'Neill and colleagues have done that in 20 cities. It is about 3% of projects that were ultimately approved that faced CEQA litigation along the way. But that is not a meaningful, in my view, that's not a meaningful number because it's not telling us about either the projects that were never proposed in the first place or the projects that were withdrawn because of CEQA litigation or the projects that got through but were much more expensive than they would have otherwise been because the developer had to pay off a bunch of groups in order to get their project across the finish line.
Thank you, Chris. Sadie, do you have anything to add?
Yeah, I mean, I think that's a great answer because there are imperfect studies. I know, a study by Holland and Knight, suggests that 80% of CEQA lawsuits, target infill housing. And I think, of course, the data is not there to support broader claims about how many units and what that would look like, especially considering that California is a difficult place to develop for a number of reasons, and especially in home rule cities. But I think it is, I think one of my takeaways from that study is that it is predominantly being used to target, multifamily infill housing and not, industrial development and developments that typically have the huge environmental impacts that you'd expect.
Thank you, Sadie. And I just want to encourage the audience, if you have questions, please drop them in the Q&A area and we will try to get to as many of them as possible. The next one is SB 9 creates an exemption and makes quadrupling or more densities without environmental review. How is that good? And you can jump in. I don't know if Sadie or Chris would like to answer.
I'll start off. My understanding is that, the recent suite of housing bills, made made certain projects subject to ministerial review rather than discretionary review. And so really what that means in practice is if it lines up with a city's general plan, or everything checks the boxes, then you can develop that project, and that really takes the guesswork out of what is or is not okay if it lines up with a general plan that has already gone through an EIR process, has already gone through those checks, that the environmental review has been done. And I think for when thinking about ADUs and additional units in infill locations, that again, going back to kind of understanding CEQA in light of our regional, climate smart development, we want to be promoting building more units in our existing communities, and so I think that is, it's taking the hyper local impacts of an extra story or an extra car on your street, or more neighbors, which some people can call environmental impacts and other people call like a great place to live, and instead thinking about it in terms of, okay, this is what we need as a city, as a state, as people working towards a common goal to like really make communities that can withstand climate change. And I think that's a big part that's missing from that small view of environmental impact that just thinks about your block.
I agree.
I love it. Thank you. So the next question is, let's see. Over the years, adding issues to environmental checklist has worked fairly well. What about adding environmental justice and the environmental benefits of the project to the checklist? I don't know who wants to start.
I'll start. I think adding environmental benefits to the project to the checklist doesn't achieve anything unless there are much more fundamental changes made to CEQA itself. Because right now, if there is a fair argument that the project may have any adverse environmental impacts on any geographic scale, although in practice, the focus is usually locally, the project requires a full environmental impact report. No matter how great the project's environmental benefits might be in 59 different ways, if the 60th item on the checklist is a fair argument that there might be some marginal significant impact, the project has to go through the EIR. So there's just no point on the check as things are set up now to add environmental benefits to the checklist. As for adding environmental justice to the checklist, I don't see what that would achieve, because again, already right now, if there's a fair argument that the project would have any adverse environmental impact, whether it's on a person of color or a white person or a whatever person, it has to go through an environmental impact report. So anything that could possibly be an environmental justice impact is already an environmental impact within the meaning of CEQA.
Thank you, Chris. Sadie, would you like to add to that?
Yeah, I mean, I can't speak in depth. I think it's an interesting thing to think about or to look into. But I think, on the other hand, it's also one of the issues with the checklist of, okay, you put it on the checklist and then you just have to show how to mitigate it. And in a lot of cases, there are these lawsuits come out because there's things that are bigger than that. You know, a bigger question of is this right in this place? And so I'm not sure it would change. I'm not sure how much it would change how it's being used, or if it would be, you know, easier to use for environmental justice communities. Because I think, you know, I think it's already, there's already a system in place of how it is being used. And I don't think the checklist would do that, but it might. I think it's interesting to think about. Thanks for that question.
Thank you. So we're getting close to time. I can't believe this has gone by so quickly. We'll try to do a lightning round with a few of the questions. We're not going to get to all the questions in the chat, but let's see. Let's go to this next one. Lots of CEQA issue topics are now addressed in other areas of the law: air quality, noise, hazardous material. Is someone working towards getting other important issue topics, archaeology, tribal cultural resources, addressed outside of CEQA as a way to protect resources impacts in conjunction with scaling back CEQA?
I think that's a really, really great question. OPR tried like 20 or 30 years ago to create a presumption that an environmental impact was adequately mitigated if there was a specific state or local law addressed to that type of impact and the project complied with applicable standards under that law. And the courts shot that down. I thought it was like an unbelievably egregiously bad judicial decision. But it was from the heyday when anything that was seen in any way as limiting CEQA in any way was regarded as bad for the environment. And so that effort failed. But if you look at New Jersey, for example, New Jersey has a form of environmental review for housing projects, but the environmental review takes place before state agency, not before the local government. And what the state agency does is that they verify that the project complies with applicable requirements under the state coastal protection laws, the state wetland laws, the state forestry laws, et cetera. And that seems to be a system that results in both effective enforcement of state law and much less litigation and kind of strategic use of environmental review than we see in California.
All right. Sadie, would you like to address that question?
Yeah, well, you know, I think baked into that question was scaling back CEQA, and I think that is not, you know, CEQA is certainly been a powerful tool in protecting the environment and protecting our communities. And so I'm tentative to say scaling back CEQA. I think strengthening and reforming CEQA to make it actually make sense in terms of our climate goals and, you know, our community goals is what we need. But I don't think you know, scaling back CEQA in a broad scale is what you know I'm advocating for. But really just having it be, you know, really restoring CEQA to an environmental protection statute that can do just that, and doing that through, you know, some nuanced reforms.
Thank you both for your questions. Unfortunately, we've reached the end of our time today. I know there's some really great questions, and I am hopeful that the team could take those questions and perhaps put out some answers so that they're at least addressed in some capacity. I want to thank the panelists for their incredible insight to all of the questions that were put in the chat today. And the next day or two, Sql team will be sending out an email to all of you with a link to today's recording and other resources that our panelists would like to share. You may also hear from urban environmentalists and from our event co-sponsors. Before I turn it over to Jackson, I want to see from the two panelists, any final thoughts before we turn it over to Jackson? And if not, Jackson, would you like to come in and close us out?
Yeah, absolutely. Thank you so much, Lisa. Thank you to Chris and Sadie for both joining us. Thank you all for coming, and Wesley as well, who was the mastermind behind this entire panel. I also want to thank all of our SPUR members for joining today. If you're not a member of SPUR and would like to join, you can find out more information on our website at spur.org. Thank you all and have a great rest of your evening. Good night.